Being made redundant can come as a welcome relief and an opportunity to take your career in a new direction, or it can come as an unpleasant and unwelcome shock. However you feel about it, it's important that you know your redundancy rights under employment law. Firstly, you have the right to be consulted by your employer. They're obligated under employment law to include you or your representative, if there's a collective redundancy situation, in talks aimed at finding an alternative to redundancy. Secondly, you'll be entitled to statutory redundancy pay if you have continuously worked for your employer for a period of 2 years or more. You should also be aware that you're entitled to a statutory minimum notice period before your employment ends. The calculation of your redundancy pay and notice period depend on a number of factors, including how long you've worked for your employer. If your employer does not acknowledge your redundancy rights, you may be entitled to make a claim against them. Your employer cannot select you for redundancy for any old reason. The reason must be fair, objective and lawful. For example, your employer can dismiss you if your job no longer exists, or a need to reduce costs means some jobs have to go. However, if your employer uses redundancy as an excuse to remove you from their employment, for example because you're pregnant or they simply don't like you, then you may have an unfair dismissal claim against them. If you think you may have a redundancy claim against your employer, call us today and speak to one of our trained advisors. They'll listen to your situation and advise you on whether you need to speak to a specialist employment solicitor.